Namaste everyone. Welcome to Courts This Week on LiveLaw. I am Taniya Pandey, and every week we bring updates regarding the most recent judgments and orders delivered in various courts across India. To stay updated, subscribe to LiveLaw and click the bell icon to not miss any videos from us. In today's video, we'll cover judgments from the last week of April, so let's get right into it. The Supreme Court on 28th April clarified that Rule 17 of the 2021 Draft Criminal Rules on Practice, which the High Courts have been directed to adopt, should be read as a mandate for furnishing of the bail order to the prison concerned, and the concerned prison, in turn, should furnish the same to the accused on the same day of pronouncement. The bench of Justices L. Nageshwar Rao, S. Ravindra Bhatt and B.R. Gavai also recorded that many high courts and state governments are yet to incorporate the draft criminal practice rules approved by the Supreme Court last year. In a significant judgment, the Supreme Court has held that Anganwadi workers and Anganwadi helpers are entitled to the payment of gratuity under the Payment of Gratuity Act 1972. A bench of Justices Ajay Rastogi and Abhay Soka allowed the appeals filed against a judgment delivered by the Division Bench of the Gujarat High Court. The issue involved in these appeals was whether these workers and helpers appointed to work in Anganwadi centres set up under the Integrated Child Development Scheme are entitled to gratuity under the 1972 Act. Justice Oka noted that Anganwadi centres are performing the statutory duty of implementing provisions of Sections 4, 5 and 6 of the National Food Security Act 2013 to ensure nutritional support for pregnant women, lactating mothers and children. In this backdrop, the court observed that Anganwadi workers and helpers are holding a statutory post and that Anganwadi centres are establishments within the meaning of Section 3B of the Payment of Gratuity Act. The Supreme Court, in a judgment delivered on 27th April, explained the group of companies doctrine, which postulates that an arbitration agreement entered into by a company within a group of companies can bind its non-signatory affiliates or sister concerns if the circumstances demonstrate a mutual intention of the parties to bind both the signatory and affiliated non-signatory parties. The bench of Justices D.Y. Chandrachud, Suryakant and Vikramnath observed that a non-signatory may be bound by the arbitration agreement where there exists a group of companies and where parties have engaged in conduct or made statements indicating an intention to bind a non-signatory. Observing that fair and impartial investigation has not been carried out in the case relating to the alleged custodial death of Mohammad Faisal in a police station in Unnao district in the state of Uttar Pradesh, the Supreme Court has ordered further investigation into the matter by a senior officer. The court noted that none of the police officers who are made witnesses in the case have supported the prosecution, and yet a charge sheet was filed. The charge sheet was filed for the offence of Section 304 of the Indian Penal Code, which is culpable homicide not amounting to murder. The Sessions Court altered the charge to the offence of murder under Section 302 IPC. The 17-year-old boy was allegedly assaulted by the police for selling vegetables violating lockdown norms. A bench comprising of Justices Ajay Rastogi and Bela M. Trivedi passed the order in a petition filed by the mother of the deceased. While hearing a plea with respect to appointment of protection officers, POs, under the Protection of Women from Domestic Violence Act 2005 across the country, the Supreme Court on 25th April noted that it is not sufficient to only appoint POs but to also provide them with assistance. It observed that in this regard, National Legal Services Authority, NALSA, is taking steps to appoint protection assistants in every district. A bench of Justices U. Lalit, S. Ravindra Bhatt and P.S. Narasimha suggested that Anganwadi and ASHA workers can be inducted as protection assistants as they would be more approachable for the aggrieved women, especially in the rural areas. The Supreme Court has observed that High Courts should be slow to grant a relief of quashing of a complaint under Section 138 of Negotiable Instruments Act at a pre-trial stage. In a situation where the accused moves the court for quashing even before the trial has commenced, the court's approach should be careful enough to not prematurely extinguish the case by disregarding the legal presumption which supports the complaint, the bench of Justices K.M. Joseph and Rishikesh Roy said. Let us now go over important judgments from different high courts and other courts. The Kerala High Court recently quashed all charges pending against a village officer who attempted to commit suicide and was booked under Section 309 of the Indian Penal Code. After an elaborate study of the general judicial opinion on the issue, Justice K. Haripal observed that the growing trend was in favour of decriminalisation of the offence, since suicidal behaviour is often considered to be a symptom of mental distress. The High Court of Madras has held that the challenged proceedings under Section 34 of the Arbitration and Conciliation Act are summary in nature, and therefore the same shall be decided based on the record that was available to the arbitral tribunal, and no additional documents shall be permitted to be brought in at that stage unless absolutely warranted. The single bench of Justice M. Sundar further held that the court would not allow any additional document under Section 34 petition if there was nothing that prevented the petitioner from furnishing the same document before the arbitrator. The Chhattisgarh High Court has quashed the 5-year ban imposed by the Government of India and Pharmacy Council of India on the opening of new pharmacy colleges in the country for the next 5 years. The judgment came in a petition moved by a batch of colleges before the High Court, which were finally allowed by the single bench of Justice P. Samkoshi, which termed the ban in question as unconstitutional, monopolistic, and discriminatory in nature. The High Court of Delhi has held that the sufficiency of the stamp duty on an arbitration agreement is a jurisdictional issue under Section 16 of the Arbitration and Conciliation Act. The single bench of Justice Sanjeev Narula has held that an objection as to the deficiency in the stamp duty shall be decided as a preliminary issue, since the inadequately stamped arbitration agreement can neither be taken in evidence nor can be acted upon, and therefore the tribunal should direct the parties to first get the agreement sufficiently stamped before adjudicating the rights and obligations under the agreement. The court reiterated that when an insufficiently stamped instrument is presented before the arbitrator, he shall impound the same and direct the parties to pay the requisite stamp duty. The National Company Law Tribunal Amravati Bench, comprising of Justice T. Rajani as judicial member, while adjudicating upon a petition filed under Section 7 of the Insolvency and Bankruptcy Code 2016, has initiated corporate insolvency resolution process against Andhra Cement Limited. The order was passed on 26 April. The adjudicating authority observed that there is an admission of debt and default, and the reasons accorded by the corporate debtor cannot be considered within the IBC framework. The Hyderabad Bench of Customs, Excise and Service Tax Appellate Tribunal, CESTAT, has ruled that Section 113 of the Customs Act only provides for confiscation of goods that are to be exported and not for the goods which have already been exported. The bench, consisting of P.K. Chaudhary as judicial member and P. Venkat Subbarao as technical member, held that the purpose of the Drugs and Cosmetics Act 1940 is not to regulate exports, but only to regulate the import, manufacture, sale and distribution of drugs and cosmetics. The CESTAT added that any illegality or violation of any law, which is not a prohibition of export under the Customs Act or under any other law, does not attract the provisions of Section 113D of the Customs Act for confiscation of goods. With this, we've come to the end of today's episode. Thank you for joining us. I am Taniya Pandey for LiveLaw and you're watching Courts This Week. Have a lovely day.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.